All right, you've been charged with second-degree assault in Minnesota. What that means is that the prosecutor is alleging that you used a dangerous weapon. If they allege that you used a dangerous weapon but there was not substantial bodily harm, then the maximum prison sentence is 7 years. If, however, they allege that you used a dangerous weapon and you caused substantial bodily harm to the alleged victim, then the penalty goes up to 10 years in prison. Substantial bodily harm is things like a broken nose or a lot of stitches or other broken bones. Even knocking somebody out can be substantial bodily harm. With respect to a dangerous weapon, it's actually defined under Minnesota law, and what it typically means is a gun, whether the gun is loaded or unloaded. It can be a device designed as a weapon and capable of producing great bodily harm or death, so things like a knife or a hatchet. Things like that. A sword could be, for example. Also, any flammable or combustible liquid could be. So if you try to start somebody on fire or you use a bomb or something like that, that's a dangerous weapon. And then anything else that, whether it's intended to be used or not that way, if it's intended to be used to assault someone and it's capable of producing harm, then that can be a dangerous weapon. And so that's where the law gets really tricky. I once had a case, for example, where the prosecutors alleged that my client hit somebody with a hockey stick. It wasn't during a hockey game. They said he robbed him and he used a hockey stick as the weapon, and he beat the heck out of the guy with a hockey stick. They alleged that the hockey stick was a dangerous weapon, that because it wasn't made to assault people with, but that this guy used it in a manner to assault someone, that it became a dangerous weapon at that time. We argued successfully against that, but the law is endless with examples where prosecutors will try to say something is a dangerous weapon. That's really important because there are defenses to these things. For example, if I can get the dangerous weapon thrown out and get a judge to agree or a prosecutor or a jury to agree that whatever was used is not a dangerous weapon, then the degree of the assault falls from a second-degree assault down to a third-degree assault, or maybe even down to a fifth-degree assault. So all of a sudden, you're not facing prison time potentially. So that's one important defense, if you can prove that whatever was used was not a dangerous weapon under law, and it takes a good lawyer to argue those things. Another defense is whether there's substantial bodily harm or not. Sometimes prosecutors will argue that a scratch or a bruise or something is substantial bodily harm, and we'll argue no, that's not enough to be substantial bodily harm, that's just bodily harm. Again, that can lower any consequences you're facing. Indeed, there are other defenses like self-defense, alibi, lack of intent, intoxication. These are all good defenses in second-degree assault cases. It takes a lawyer that knows how to take these cases to trial and knows how to present these defenses to save you from being prosecuted or from wrongfully pleading guilty to a second-degree assault charge because you're intimidated about it. If we're able to get a second-degree charge thrown out, then the prosecutors have to fall back, like I said, on charging you with a third or fifth-degree assault, and your exposure is a lot lower. So make sure you get a lawyer who knows how to handle second-degree assault cases. Make sure you look at whatever alleged weapon was used as to whether or not that's really a dangerous weapon under the circumstances. Make sure you see if there was substantial bodily harm, and make sure you have a lawyer that you're not afraid to go to trial with in a case like this. My name is Ryan Pasiga. If you've got other questions, I'm at 612-339-5844, or check out my website at arrestedminnesota.com.